So welcome, it's nice to see you all. I'll be doing the introductions to this day of the AI and Law Conference. I think it was the month of December when Sveta Kostic and I talked about organizing an AI and Law Conference. And the idea developed since then to make the Belgrade Legal Philosophy Week all about artificial intelligence and law. We wanted and we were trying to make a day that would be devoted completely to the legal practice, or that would completely be devoted to the relation of artificial intelligence and legal practice. We probably wouldn't be able to pull it off if there wasn't for Jelena Arsic and for Schoenherr, Moravčevic, Vojnovic and Partners in cooperation with Schoenherr. And it is to their credit that we are organizing this day here in this wonderful, wonderful room. I think that this must be the nicest room for holding a conference that I've ever been in. This day is, as planned, completely devoted to issues or practical issues that arise out of mostly generative artificial intelligence, but also previous generations of artificial intelligence and legal practice. We usually do philosophy of law, but we left those issues to be discussed tomorrow. Today, we are going to do two panels, and the panels will be devoted, or are tentatively called, Use of AI in Law and Abuse of AI in Law. But before we start with our panels, we have with us our keynote speaker and a very distinguished guest. When I was planning the conference, he was one of the three persons that I wanted to have in Belgrade. Our guest today is Burkhard Schafer, a professor of computational legal theory at the Edinburgh Law School, University of Edinburgh. He studied theory of science, logic, theoretical linguistics, philosophy of law at the University of Mainz, Munich, Florence, and Lancaster. His main field of interest is the interaction between law, science, and computer technology from doctrinal, comparative, and legal theoretical perspectives. His research encompasses both the problems of technology and technological change and the problems in law that are brought about with this technological change, and the use of technology in the justice system and the legal services industry, legal informatics. This use and abuse, of course, dates much more back than the current generation artificial intelligence models. He's the co-founder and director of the Scripps Center for IT and IP law, covering all aspects of technology regulation, from IP law to data protection to e-commerce and e-forensics. This led to his involvement with creative informatics, a large research and development project for the creative industries. As a co-founder and co-director of the Joseph Bell Center for Legal Reasoning and Forensic Statistics, he also worked on questions of legal technology and its role in the justice system. He's involved in a number of organizations that promote the exchange between computer science and law, including the German Association for Informatics and the Evidence and Investigation Network of the Scottish Institute for Policing Research. He's currently a member of the expert group AI for People, chairing their working group on ethics frameworks for legal technology, and a member of the data ethics group of the Turing Institute. So today, Professor Schafer will tell us about artificial intelligence and the future of legal professions. Without further ado, I invite Professor Schafer to come to my place and give him the floor.
Hey. Thanks a lot. Thanks a lot for the kind invitation. It's my first time in Belgrade, and I just come out of a really brilliant tour through the city, which gave me lots and lots of background about its history, about the communities that have been living here. And while I was listening to it, I was more or less reorganizing already the talk I was going to give to you. So the fact that I won't be able to use my slides is a bonus, because it allows me to be slightly more flexible than I would otherwise have been. I just have to keep time a little bit. Of course, those who know me know that I can talk about law and technology without stopping for 3 days, and then I'm running out of drink, essentially. And that is the only reason why I will stop normally after 3 days. So let us take you back a little bit to the time when I started being active in this field. I had just completed my degree in computer linguistics, was just moving into law. It was the late 1990s. And at that time, Richard Susskind wrote a very influential book, The End of Lawyers, in 1998, where he more or less predicted that law as we understood it was reaching the end of its shelf life, that there probably wouldn't be lawyers by 2005 or thereabouts. It's probably safe to say that didn't quite happen. You're still here. Nor was he the first person to predict that law as a discipline would disappear as a result of technological change. The first person who explicitly did that was Napoleon Bonaparte. He predicted that this new technology, cheaper printing press, together with the Code Civil, would make lawyers redundant, because every citizen would simply have a print copy of the Code Civil in their house. And who needs lawyer? So if you can simply look up what the law is in the approved textbook. So I think we should be careful about claims that technological change will substantially change the nature of law. Law deals with the human condition. Law deals with human conflicts, our ability to cooperate. And these human constants will be with us regardless of what technology is doing. So I think the first point of warning is that now that AI in law again grabs the headlines, we have been there before. And to a certain extent, we were disappointed. In other respects, we probably had change that were so subtle that we don't even notice them any longer. And we don't think of them necessarily as legal AI. I do my tax returns online. In the back runs a AI, by 1990 standards, a good old-fashioned AI, a legal expert system that makes sure that I do the right things. We don't think of that any longer as AI, but it definitely transformed quite substantially how ordinary citizens interact with the state. So that, just as introduction, what Susskind predicted at the time was that there would still be a limited room for bespoke legal services, where you deal with an individual important client in an important matter and still charge them by the hour, the hourly billing model, but that increasingly we would move to commoditized legal services, where people simply download the right type of system from a website, do it by themselves, and because the costs of delivery are close to zero, we need to find different business models for law firms to capitalize on their expertise. That was, broadly speaking, his vision. 20 years or so later, we are again talking about a fundamental change in the legal profession. What has changed? What of his predictions has become true? Well, to a certain extent, we do find AI in the widest sense fulfilling his vision of commoditized legal services. By now, if you are an ordinary citizen, if you don't have complicated assets, if you just have your children and you don't hate them that much, and maybe a wife or a husband, and you want to write a will, there are clever systems, clever document drafting systems that do it for you. You don't really need a lawyer for that. And that definitely has an impact on the business model, especially of smaller law firms. So in some fields, we do find that this notion of commoditized legal services, buying law as a software program has materialized, but probably not to the extent that he had anticipated. Back in 2017, we carried out a study with the Law Society of England and Wales on the impact of technology on legal practice. And while it is difficult to be that precise, our indication of finding broadly was, yes, there is an impact. It has an impact on the job market. It hasn't recovered from the global financial crisis as much as other industries, but it is still probably within the statistical margins of error. Something seems to be happening. What is exactly happening is difficult to pin down, to put it mildly. It's very difficult to say. I won't treat that study with great caution. During that time, we had a global financial crisis. We had a change in government that changed the structure of legal aid substantially, a huge impact on law firms. We had other developments outside the field of technology that also had an impact on the legal job market. But there seems to be slightly fewer places available to especially paralegals and trainees, simply because law firms have been able to standardize, automatize some of their processes. So that is what the evidence indicates. Some of the biggest headline-grabbing technologies, like Do Not Pay, a chatbot lawyer that helps to overturn 160,000 parking tickets in London and New York, they are not in competition to legal services, to law firms. They are essentially moving into a space that in the past was underserved by the legal profession, something where hiring a lawyer would not have been an option anyway. There we definitely see some success stories, some impressive impact on the way citizens live, but I don't think they had a major impact on the business models of law firms. On the other hand, some really high-profile headline-grabbing cases like AI predicts outcome of human rights cases. Do we need judges any longer? Yeah, they are sort of interesting research papers, but their impact on practice seems to be nil. And personally speaking, none of the systems in that space particularly impress me. Leaving aside the fact that why should predicting the outcome of a case make it unnecessary to adjudicate the case? When my home team, Hibernian football team in Edinburgh, plays against Bayern Munich, I can predict you the outcome. Doesn't take a genius, actually. Unless there's a major case of food poisoning in the Bavarian team, we will lose. But that doesn't mean we shouldn't play. And for justice, I think doing it, the performative aspect, having people in court, allowing them a voice, giving them the space to air their grievances and to make their arguments is as important as getting the outcome right. And justifying the outcome, explaining it, not just to the parties, but to society as large, reminding them what our values are, is equally important as getting the decision right. So merely predicting an outcome, apart from very few exceptions, I don't think matters actually that much. But that might be just me. So some of the bigger, more exotic forms of AI might not be the ones that we are actually looking for when we are looking for impact on law firms. There's a study at the moment underway in Poland by my good friend and colleague Michael Moravčevic, where we interviewed a lot of law firms. And again, that confirms the trends and observations that I have made. By and large, technology in law firms is used to do the things you always did slightly faster, slightly cheaper, slightly more efficiently. A lot of it is about processes and procedures. It's about data management. It's about the flow of a case management. A lot happening in that space. Good stuff, undoubtedly, but nothing that is fundamentally new, I would say, to law and the legal business model. What we don't find, and by and large I'm happy about that, is radically new business models premised on data. And if it really were true that we can commoditize law and make simply legal services available for free through appropriate software, what would be the business model for a law firm? Well, we have a blueprint for that. Meta or X, selling your client data. Wouldn't it be great if an insurance company could get the accumulated, anonymized data about people who are so unhappy about a product that they consider product liability litigation? We don't see that. We don't see the recognition of data as a good in itself, as a commodity in itself in the law space, partly because we are a regulated profession. I think it's a good thing, but it closes some of the doors that are otherwise available for law firms to adjust to this new reality. There's one field which I'm very, very skeptical about. It has little to do with AI. It's more a technology-enabled trend, but that is changing the landscape, at least in the UK, also in the US. I don't know if it is an issue here, but that is new forms of litigation financing. The Patreon model of litigation, or the FoundMe crowdfunding model of litigation, where lots and lots of people get a good case made. You are interested in this legal development, give us a bit of money and it might flow back to you. I find this extremely problematic. I'm not entirely sure that this is a good way forward. We saw litigation in the UK on highly politicized topics, which in my view had no chance of winning, but where lots and lots of ordinary people lost quite a bit of money they probably couldn't afford. So I think here we find a radical change in the traditional business financing model, technology enabled, and here AI might be a mitigator. If these people could get independent legal advice, and if it is by an AI, is there any chance in your case going ahead? Or is this pure nonsense? That might help to push that into a more benevolent directions. But broadly speaking, I think it has been business as usual for most of the law firms that replied to us. And in particular, old divides tended to prove persistent. Large law firms embrace technology much more. They start to have legal knowledge engineers. Pinsent and Mason has an excellent legal knowledge, chief knowledge engineer. I know that, I taught him. Sorry. But it is the exception. There is a certain move towards this. Smaller law firms essentially do things differently. They are mainly interested in things like compliance, again, process management, document management. A hope some people had that with AI, smaller law firms would be able to take on larger cases that were previously the domain of well-resourced larger law firms with lots of staff. Again, that doesn't happen. At least it doesn't happen according to the data that we have. One other thing has changed since the 1980s, and I think that is a reason why things will be different this time around, and that is that more legal data is already born digitally. LexisNexis, Westlaw, Thomson Reuters make court decisions, statutes, now routinely available in a digital form. Courts publish more in a digital form. So something that was a huge problem in the 90s, sustainability. How do I update the system? How do I make sure that new data is fed in continuously? That now starts to be taken care of by large digital publishers. And they are, for me, probably the most overlooked stakeholder in the transformation of the legal service industry. They were the ones, even during the AI winter, who kept investing in AI. Legal information retrieval is definitely one of the success stories of AI. They are the ones who are now buying off the AI startup companies. Lex Machina, one of the most innovative AI providers in the US, that analyzes party submissions in intellectual property cases, again, to predict court outcomes, was bought by LexisNexis. I don't think that is a coincidence, and we find that as a pattern. So what we are seeing is that they are still providing the traditional service to law firms, supplying them with data, but now bundle it with lots and lots of small individual add-ons. Not because they want to change the legal services industry market, but because it distinguishes them from their competitors. For them, it is a fight, LexisNexis against Thomson. Who has the most added value to provide to you as a customer? For me, that again means, on the one hand, probably quite a lot of the life for lawyers remains the same. They are not going to push legal practitioners out of business. They are the customers. But it means that quite a lot of legal firms will be more and more dependent on their contract with these publishers. Technological lock-in is, I think, going to be a serious problem also for issues like professional responsibility and independence. How independent are you as a professional if all your services depend on LexisNexis, Thomson Reuters, whoever renewing your contract? What happens to our justice system if their servers go offline? I would say quite a lot of our cases in Scotland would have to be delayed because courts don't get access to the information any longer. I would say they are potentially a critical infrastructure now that should come in Europe under the NFTI directive. I told that to them and they offered me money to shut up. No, sorry, they didn't. But they were not particularly enamored by the idea that they were now providing a critical infrastructure with all the obligations that comes with it. But I do think that delivering justice, running the justice system is increasingly dependent on these large, quasi-monopolistic digital service industry providers. And I think that needs to change the way we deal with them in law. Maybe not necessarily as an FST provider, but they are operating outside professional legal responsibility. And that is quite nice for them. They don't need to take out professional indemnity insurance, for instance. But maybe they should. Maybe we should bring them in. And that is one of the things we have been discussing in Scotland, a little bit at least, as one way to adjust what we are doing. One of the things we noticed was that there was no career for IT specialists in law firms. They were treated as IT support. They had to deal on the daily business with a senior partner who couldn't start his computer any longer because it wasn't plugged in. And that is honestly true. I know the law firm, and I won't mention it. People who clicked on attachments even though they were told they shouldn't and suddenly had a virus on their computer. That's the sort of bread and butter job. And now, in addition, they had to do all sorts of exotic stuff with IT. But there was no real career progression. And one of the things we did in Scotland because of that was to create a new specialism, the legal technologist. And for the first time, the Law Society accredits these people even if they are not lawyers. So if you are an IT specialist, if you can show that you worked in the legal domain for an extended period of time, that you have specific domain knowledge, you can at least get accredited by the Law Society. That demonstrates that you have a certain type of knowledge, a certain type of reassurance. Ultimately, that hasn't happened yet. We hope to bring them within the remit of professional regulation, making legal IT a professional regulated body just like lawyers. I think this is absolutely necessary. We have a historically inherited, slightly insane model where certain professions, medicine, accounting, law, are regulated profession because they were so important in the Middle Ages. That is where it goes back to the old guild system. We now have technologies, jobs that are as important for society, but we don't have the same regulatory structure. I think that has probably to change. And the computer society in the UK is moving into that direction, but it is a slow and difficult process. When I teach law students, first-year law students, I always ask them, how many of you have already given legal advice for money to someone? And in a room of 350, 2 or 3 hands go up, former paralegals who now want to do a proper degree. If I do that with first-year informatics students, 99% of the hands go up. They've all done it already, for friends, for family, for small businesses. Why? Well, because no one cares, even though if they got it wrong is, I think, probably just as important as lawyers getting it wrong. So I think that is, for me, the very, very broad picture that we see emerging. Less change than one might have expected, still some socially problematic developments. And what I want to do first, and that is the result of the talk I just had because it aligns with some things I did, to mention one technology that has often been overlooked when we talk about technology, and that is automated translation. We don't think of that as legal tech, but I think it will have the most profound impact on the way our justice system operates, much, much more than court decision predictions, much, much more than decision-making tools. For the first time, people who are not speakers of the majority language will be able to communicate and interact with the legal system almost as equals. For jurisdictions like the EU, where you have multi-jurisdiction decisions, could be a sea change. Suddenly, it might be even mandatory for a German judge also to take into account decisions of an Hungarian court interpreting a European directive or regulation, as it does taking into account of a French court, which they already do simply because they learned French at school. So suddenly the jurisdictions from the periphery of Europe might be as accessible, contributing as much to the case law of the European Union as those at the center. That would be a massive change, I think, in the way we think about European law and the way it develops. It is equally important for countries that have officially recognized minority languages. In the UK, that is English, Welsh, and for myself, Gaelic, Tribliana Gaelic, one of our officially recognized minority languages. But according to the European Charter for Minority Languages, also Scots. For the first time, we will be able, on a very large level, to supply people legal documents, legal decisions in their language. Serbia, obviously, an even more interesting and more complex case than Scotland. I'm basing this on the latest report I have from the European Charter from 2005, so I might be slightly out of date, but I'm counting here Hungarian, Slovak, Albanian, Romanian, Bulgarian, Russian, and Macedonian as officially recognized minority languages because there are more than 15% of speakers in some regions. One of these is different from the others. Hungarian, Slovak, Albanian, Romanian, Bulgarian, Russian, Macedonian. One of them is different.
Politically or linguistically?
In the context
of the politics, Russian.
Yes, in a way. It aligns. That is, Russian is the one language, not Russian, obviously, but Russian is the one language that Google Translate does not support. All the others work in extreme various level of adequacy. That one doesn't. In Austria, where I'm working at the moment, it is Romani, which is not supported. All the other officially recognized minority languages are. So if we are using systematically the massive improvement that we had in machine translation to make real the rights of minority languages under the European Charter, there will be some languages that lose out, simply because for them we don't have the language models. So the question could become, what are the duties of states to assist lesser resourced languages in this environment? What do we do with their speakers if everyone else increasingly relies on automated translation? So from a perspective of access to justice, also dealing with immigrant communities, refugees, asylum seekers, automated translation is for me the game changer in the legal profession, much, much more than dedicated legal tech. So let us remind me quickly and probably wrap this up.
Yes.
Yeah, I was worried about that. Did I mention that I can talk about that for 3 days? Why do we need legal philosophy for that?
Yeah.
Obviously, if you look at Europe, if you look at the EU AI Act, it is now proposing a regulatory framework for artificial intelligence. Legal AI will always be a high-risk application under that proposal. Everything that is dealing with law enforcement, migration, asylum and border management, administration and justice and democracy are high risk. As a result, they will have to comply with these much more burdensome rules. Compliance, according to the EU AI Act, means also and predominantly complying with industrial standards set by the European standards agencies. That works extremely well if you are doing product liability. And that is where the EU AI Act comes from. That is a consumer protection product liability regime. It works well for toasters. It's just as quite the same thing as toasters. Is buying justice the same thing as buying a toaster? I would say no. I would say there are fundamental differences. But are we going to get hurt? The important thing for me is, as philosophers, as practitioners, we need to have an input in these standard-setting bodies, which will determine what is permissible and what is not permissible in terms of legal tech. And for that, we need legal philosophy, because we need to know what are our expectations of a just society and of a good legal system, to have a normative standard, and also what does it mean to formalize the law? What is legal knowledge? What is the nature of what we are doing? Because the standard-setting bodies don't know that. They don't know that. They know how a toaster works. They don't know how the law works. So nothing is as practical as a good theory. I think we need both theoretical, philosophical reflection and the practitioner impact to shape the industrial standards, which will increasingly determine what can and cannot be done in the space of legal tech. And with that, we have made a journey from the 1990s to the present, and hopefully gave you some thought, food for thought. Thank you.